Today, we're plunging into a truly monumental piece of UK legislation, the Data Use and Access Act 2025.
Yeah, monumental is the right word.
This act is designed to fundamentally reshape how data is managed, shared, and protected across the country. It touches everything from your personal information to, believe it or not, how roads get dug up.
It's a significant leap, definitely. It pulls together a surprising number of, well, quite disparate areas under a single legislative umbrella.
Right.
Our mission for this deep dive really is to extract the most crucial insights from this pretty extensive document, helping you understand not just what it says, but what its real-world impact and implications are, for you and for businesses.
We've meticulously gone through the official King's Printer version of the Act that's the final enacted law, alongside relevant bits from the Data Protection Act 2018.
Yeah, the as enacted text.
Our goal is to give you a shortcut to being genuinely well-informed, complete with those sort of aha moments where something clicks into place that you might not have realized.
Hopefully a few of those.
Okay, let's unpack this. What immediately jumps out to me is just how incredibly wide-ranging this act is. I mean, the title, Data Use and Access Act 2025, sounds quite specific.
It does, yeah.
But the actual provisions stretch across so many different aspects of modern life, it feels like much more than just data sharing.
That's really the key insight here. The breadth is quite something. This act isn't just adding a few tweaks. It seems like an attempt to future-proof data legislation, maybe.
Okay.
It explicitly covers, everything from access to customer and business data, managing street apparatus info, that's the NUAR bit we'll get to.
Or the pipes and cables.
Exactly. And modernizing birth and death registers, all the way to regulating personal data processing, electronic communications, PCR updates, and even tackling complex emerging issues like copyright for AI systems and the creation of deepfakes.
Wow.
It's a strategic shift, aiming for a more holistic, integrated approach to data governance across, our entire digital and physical infrastructure.
So it's not just about what companies can do with your data. It's about the whole ecosystem of digital information and its practical, real-world impact.
Exactly.
Which naturally leads us to the question, what does this mean for your direct control over your own data?
Well, the Act significantly empowers you, or aims to. It enables the Secretary of State or the Treasury to make regulations requiring data holders, think companies, organizations holding your info, to produce, collect, retain, and even fix inaccurate data if you ask them to.
Okay, so a right to correction.
Yes, and what's particularly powerful, potentially, is that an authorized person can now act on your behalf.
Right, like a third party.
Exactly. To take action related to goods, services, or digital content supplied by that data holder.
That sounds like a powerful step towards genuine data portability and letting you delegate control over your information.
It could be, yes.
But thinking practically, what's the biggest hurdle companies might face implementing this delegated control, especially, say, for smaller businesses?
That's a great question. I mean, while the principle of delegation is strong, the practical implementation, for businesses, especially SMEs, it'll likely be developing the secure, standardized interfaces needed to handle these requests from authorized third parties.
Okay, so technical standards will be crucial.
Absolutely. It requires a significant uplift in data governance and, frankly, technical capability. And beyond that, the Act also mandates that both the original data holders and any third parties who receive your data must keep detailed records of it.
So accountability down the chain.
Exactly. It ensures accountability throughout the data chain, even for these secondhand disclosures.
And if something goes wrong, if data gets misused or there's some kind of problem?
Well, the regulations can require these data holders and recipients to publish clear information about your rights and their obligations.
Right.
And also to implement robust procedures for handling complaints. So there should be a formal, clear pathway for resolution if you hit an issue.
Okay, that makes sense. Now, beyond empowering individuals, the Act also talks about creating entirely new structures for how data flows, almost like building new digital plumbing for the UK, you could say.
That's a good analogy.
I'm genuinely curious, from your deep dive into this document, what's one of the most innovative or perhaps unexpected structural changes it introduces that could really reshape how data moves between sectors?
What's truly innovative, I think, is this concept of interface bodies.
Interface bodies.
Yes. Regulations can now mandate their establishment to manage data interfaces, set industry standards, and oversee how data arrangements are actually put into practice.
So they're like rule setters for data sharing?
Kind of, yeah. They could even monitor compliance with those standards. It really points towards driving much greater interoperability and standardization in data exchange across different sectors.
And there's a really specific focus on finance in there too, isn't there? Which makes sense given how critical data is in financial services.
Precisely. The Financial Conduct Authority, the FCA, they gain powers to create specific FCA interface rules.
Ah.
Just for the financial services sector. This allows them to impose additional sort of tailored requirements on anyone linked to financial data interfaces, ensuring sector-specific regulation where, let's face it, the stakes are incredibly high.
Right. Okay, this next part truly grabbed me with its sheer practicality. The Act introduces this massive mandatory data sharing initiative that affects everyday life, something you might not even realize is happening, literally under your feet.
Ah, you mean the National Underground Asset Register, AUAR.
Exactly, NUR.
Yes, this act now requires what it calls undertakers. That's the legal term for utility companies, councils, anyone owning infrastructure buried in our streets, to upload all their relevant information into NUAR. And there are deadlines, a specified archive upload date within an initial upload period.
So all those pipes, cables, conduits under our roads, they have to be digitally mapped and shared in one central place.
That's the plan.
I can already imagine city planners breathing a sigh of relief. Maybe fewer oops was at a gas line moments when digging up the road.
Well, hopefully.
What kind of real-world impact, beyond just avoiding explosions, do you foresee from this?
Well, beyond safety, which is obviously paramount, this is a potential game changer for preventing infrastructure damage and dramatically improving efficiency in street works.
Right. Less disruption.
Exactly. Imagine roadworks completed faster because crews know precisely where everything is before they even break ground. And non-compliance. It's an offense,
Okay.
with potential liability for damage or loss unless you can show all reasonable care was taken. The Secretary of State will also regulate access to this crucial info, including setting fees to cover NUAR's running costs. It's a huge step for national infrastructure management.
That's an incredible example of data transforming public services. Does this practical approach extend to other sort of foundational public records, like birth and death registers?
It does, actually. The Act modernizes how registers of births and deaths are kept. The Registrar General can now require these registers to be maintained in any form, including entirely digitally.
So moving beyond the old paper ledgers.
Precisely, moving beyond traditional hard copies. And regulations will define how actions like, say, signing a digital register are to be legally treated. It paves the way for fully digital civic records.
Okay. Shifting gears now to our personal digital footprint. How does this act impact things like how websites interact with you? You know, those endless pop-ups we all click through.
Right, the Privacy and Electronic Communications Regulations, or PAR. The Act amends these. A crucial clarification is made. The duty to notify the Information Commissioner of a personal data breach must now be done not later than 72 hours after becoming aware of it.
Okay, 72 hours, that's clear. Faster notifications.
Faster, clearer rule, yes.
And what about those pop-ups asking about cookies specifically?
Okay, so Regulation 6, which governs storing or gaining access to information on your device's terminal equipment, basically, cookies and similar tech.
Yeah.
That's been updated. It explicitly requires that you have to be provided with clear and comprehensive information about the purpose of the storage or access, and you must give consent.
Right. But are there any specific situations where that consent isn't required? Like if a website absolutely needs a cookie just to work?
Yes, good question. There are exceptions. If the storage or access is strictly necessary for providing an information society service you've specifically requested.
Okay, so like the basics.
Think of it this way. Your shopping cart functionality on an e-commerce site, or maybe load balancing to keep a website running smoothly, those sorts of things are generally permitted without needing that explicit consent banner.
Right.
It also extends to collecting anonymous statistical information about service or website usage purely for improvements.
Ah, analytics.
Yes, but with caveats, provided that information isn't shared with others, except maybe someone helping them improve the site.
Okay.
You receive clear information about it, and crucially, you're given a simple, free way to object, and you don't object.
So an easy opt-out is key there.
Absolutely. And there's even a specific exemption for emergency assistance.
So putting that simply, for our listeners maybe running websites, Essential functions and internal non-sharing analytics are generally okay without explicit consent if you're transparent and offer an easy opt-out.
That's a pretty good summary, yeah. Transparency and control are key.
That's still quite a lot for website operators to get their heads around. And speaking of cutting-edge issues, AI and copyright. This feels like where it gets really interesting for the creative community and tech developers, too.
It really does. This is a direct legislative acknowledgement of one of the most contentious issues in AI development right now. The act mandates that the Secretary of State has to produce a report. A specific report on the use of copyright works to develop AI systems.
Right, like training data.
Exactly. And how those works are accessed for AI purposes, like web crawling for training data. This report also has to consider AI systems developed outside the UK and their impact on copyright owners and AI developers, including individuals and small businesses.
So it's forcing a formal look at the issue.
Yes. The aha moment here, perhaps, is realizing that the government is now actively required to grapple with how traditional copyright law applies to things like large language model training, an issue being hotly debated in courts all over the world right now.
Okay. The Act also dives into some deeply sensitive areas related to personal safety and crime. That feels like a powerful application of data regulation.
Absolutely. There's a significant new provision relating to the retention of information by Internet service providers, ISPs,
right.
in connection with child death investigations. Ofcom, the UK's communications regulator, gets new powers here.
What can they do?
They can now require ISPs to retain specific information, even if it wasn't initially subject to an online safety notice.
Oh.
If a person intentionally deletes or alters information required by such a notice, specifically to prevent it being available for an official investigation, they commit an offense.
Wow.
And senior managers can also be held liable. This is a very powerful, very specific tool for extremely sensitive investigations.
That sounds profound and potentially very impactful. What about other forms of digital harm, especially those enabled by these emerging technologies?
Well, the Act directly addresses purported intimate images, what most people call deepfakes.
Right, the fake images.
Yes, it does this by amending the Sexual Offenses Act 2003. It's now an offense to intentionally create such an image of an adult without their consent, or even to request its creation if you don't reasonably believe the person consents.
So creating or asking for them is illegal without consent.
Correct. And these images, which look intimate but are digitally altered or just faked, are now explicitly treated as instruments of crime for asset forfeiture purposes.
Okay, so this is a swift legislative response to the misuse of these technologies.
It appears so, yes.
And what about overall enforcement? For all these new and amended rules, who makes sure people comply?
The Act significantly strengthens the Information Commissioner's powers, the ICO.
How so?
Well, for instance, when individuals make data subject requests, asking for their data, a controller, that's the entity deciding why and how personal data is processed, can extend the response period by 2 months if the requests are complex or there are loads of them.
Okay, bit more breathing room for complex cases.
Yes, but balanced with a new requirement. A notable change is the requirement for controllers to handle internal complaints from data subjects first.
Right.
And then notify the commissioner of the number of complaints they've received.
Ah, that sounds like it could actually streamline things for individuals maybe and give the commissioner really variable aggregated data on common problems.
That seems to be the idea. It could offer a clearer picture of common issues, yes. Additionally, the commissioner gets new interview notices powers.
Interview notices.
Yes, allowing them to compel an individual to attend an interview if they suspect non-compliance or an offense has occurred.
Right.
There are also provisions for assessment notices, where a controller or processor that's the entity processing data on behalf of a controller can be liable for the costs of an approved person preparing a required report.
So they pay for the audit, essentially.
Potentially, yes.
Yes.
And failure to comply with these various notices carries increased penalties. It gives the commissioner more teeth, you can say.
This all feels like a really seismic shift in the UK's data governance landscape. And the Act establishes a completely new core body, doesn't it? That feels like a significant move.
It absolutely does. The Data Use and Access Act 2025 formally establishes the Information Commission.
The Information Commission. So replacing the ICO. Or evolving it.
Well, it establishes this new body. It will be led by a chair appointed by the King on the recommendation of the Secretary of State, serving a single term of no more than 7 years.
Okay, single term.
Yes. The Commission will have both executive and non-executive members, with clear powers to delegate functions and manage conflicts of interest. This isn't just a rebrand, it really signifies a serious restructuring of data oversight in the UK. The aim seems to be a more robust, perhaps more responsive regulatory body.
Okay. Now, one of the biggest questions for any business operating internationally is how data can be transferred outside the UK. How does this new act deal with the complexities of international data flows?
Right, this is crucial. The Act makes substantial amendments to the Data Protection Act 2018, specifically regarding international data transfers.
How does it change things?
It essentially replaces the previous system of adequacy regulations with a new system. Now, transfers to a third country or an international organization can be approved by regulations made by the Secretary of State.
Okay, approved by regulations. And what's the crucial test for that approval? Is it about having identical rules or is it something else?
The Secretary of State has to be satisfied that the data protection test is met.
The data protection test, what does that mean in practice?
It means the standard of protection for data subjects in that country, or provided by that organization, is not materially lower than the protection provided by UK data protection legislation.
Not materially lower. Okay, so it's about broad equivalence, not necessarily identical rules. That offers a bit of flexibility, perhaps.
Exactly. It offers a degree of flexibility while aiming to maintain high standards.
That flexibility sounds important, and I imagine the Secretary of State has to keep an eye on this. It's not a one-off decision.
Correct. There's an explicit duty to continuously monitor developments in other countries and, importantly, to revoke or amend approvals if that data protection test is no longer met.
Right, so things can change.
Yes. There are also new provisions for transfers based on appropriate safeguards.
Yeah.
Through binding legal instruments, things like standard contractual clauses, perhaps, and also for special circumstances transfers.
Okay.
Though these come with a proportionality requirement.
Yeah.
The amount of personal data transferred must not be excessive.
Not excessive, that seems sensible. But can transfers be restricted even if a country generally meets that data protection test? Is there some kind of public interest override?
Yes, there is. The Secretary of State can, by regulations, restrict the transfer of a specific category of personal data to a third country or international organization, even if it's not already approved under the main test, if it poses a significant risk to the rights and freedoms of data subjects.
Okay. So that's a key safety net, a public interest override.
Exactly. It gives the government an additional layer of control, even if a country generally meets the standard data protection test.
So stepping back a bit, what, in your view, really stands out about how this 2025 Act ultimately interacts with the existing Data Protection Act 2018, which is so fundamental to UK data rights?
What's truly reassuring here, I think, for individuals and businesses trying to navigate this landscape is how the 2025 Act explicitly reinforces the supremacy of existing data protection legislation.
How does it do that?
Well, it states quite clearly that any new enactments or rules which impose a duty or power to process personal data do not override the core requirements of the main data protection legislation, and that includes the UK GDPR and key parts of the 2018 Act.
Okay, so the foundational rights remain paramount.
Exactly. It's a crucial point for legal clarity. It ensures that fundamental data rights and safeguards are maintained, even as these new uses and access methods are introduced by this Act.
So, wrapping this up, what does this all mean for us? The Data Use and Access Act 2025 isn't just some technical update, is it? It's a broad, ambitious, and frankly, quite fascinating legislative effort.
Definitely not just technical.
It aims to modernize how data is handled across a huge array of sectors, from, your personal digital identity right down to the pipes under your street.
It really aims to empower individuals with potentially more control over their data. It wants to enhance efficiency in public services, like we saw with NUAR, in ways we haven't seen before, and introduce critical safeguards against emerging digital harms, like deepfakes, all while trying to carefully navigate the huge complexities of international data flows.
And the new Information Commission.
Yes, the establishment of the Information Commission really signals a major structural shift in UK data governance going forward.
It powerfully highlights that in our increasingly digital world, data isn't merely about privacy anymore, is it? It's about infrastructure, public safety, economic exchange, even personal protection, in ways we're only just beginning to fully grasp.
Absolutely. And this really raises an important question for the future, doesn't it? As technology continues to evolve at, breakneck speed, how will this comprehensive yet incredibly detailed legislative framework actually adapt?
Mm.
How will it cope with unforeseen data challenges and opportunities in the years to come? Will it be nimble enough, flexible enough to keep pace with innovation? Or will it end up needing continuous, significant updates just to stay relevant? That, I think, is the big unknown.